On the morning of October 3rd, 1995, in a courthouse in Los Angeles, California, an estimated 150 million people stopped what they were doing at the same moment to watch a single piece of paper be read aloud. The defendant was Orenthal James Simpson, O.J. Simpson, a retired football legend, a movie actor, a famous, beloved, instantly recognizable American celebrity. He was charged with the brutal murders of two people, his former wife, Nicole Brown Simpson, and her friend, Ronald Goldman, for 16 months. The case had played out live on television in front of the entire country. It became known as the trial of the century, a phrase used before, but never for an audience. This is the O.J. Simpson trial. To understand the trial, you have to go back to a warm night in June of 1994. On the night of June 12th, 1994, Nicole Brown Simpson and Ronald Goldman were attacked outside Nicole's home in the Brentwood neighborhood of Los Angeles. Both were killed in a violent, bloody knife attack. Nicole Brown had been married to O.J. Simpson for 7 years, and the couple had divorced in 1992. And there was a documented history in that marriage. That would matter enormously. Years earlier, O.J. Simpson had pleaded no contest to spousal battery. There were recordings of Nicole calling emergency services. In fear, suspicion turned quickly toward O.J. Simpson. And then came an event that the entire country watched live days after the murders. Rather than surrendering to police as arranged, Simpson left in a white sport utility vehicle, driven by a friend. What followed was broadcast on live national television for hours. A white Ford Bronco, traveling slowly along the freeways of Los Angeles, trailed by a long line of police cars with news helicopters filming from above. An estimated 95 million people watched. Crowds gathered on overpasses. When it ended, O.J. Simpson was arrested and charged with 2 counts of murder. Because O.J. Simpson was wealthy and famous, he was able to do something that almost no criminal defendant can do. He assembled one of the most expensive and talented legal defense teams ever put together. The press nicknamed it the Dream Team. It was led by Johnny Cochran, a charismatic, brilliant Los Angeles trial lawyer with a gift for connecting with a jury. It included Barry Skeck, a specialist in the still new science of DNA evidence and an expert at attacking it. It included some of the most accomplished defense attorneys in the country. On the other side stood the Los Angeles County District Attorney's Office. The prosecution was led by Marcia Clark, a determined and experienced prosecutor, and Christopher Darden, a serious and principled colleague. They believed they had a strong case, a very strong case, and in many ways they did. But this trial was never going to be only about evidence. It landed in a specific time and place. Los Angeles, in the mid-1990s, just 2 years earlier. The city had been torn by tremendous unrest following the trial of police officers in the beating of a black motorist named Rodney King. Trust between the Los Angeles Police Department and the city's black community was severely strained, and the defense team understood something crucial. This case would not be tried. In a vacuum, it would be tried in front of a jury of real Los Angeles citizens. Citizens who had lived through all of it. The trial was going to be about the murders, but it was also going to become a trial about whether the police could be believed. The trial began with jury selection in the fall of 1994 and opening statements in January 1995. It was held in a downtown Los Angeles courthouse, and by the decision of the court, it was televised. Live, gavel to gavel. That decision to allow a camera in the courtroom shaped everything. On the bench sat Judge Lance Ito. He was a careful, courteous, generally well-regarded judge. But the trial he was handed was, in a sense, impossible to control. Every ruling he made, every sidebar, every delay was watched, replayed, and debated by a national audience. The trial became a genuine media phenomenon. Cable networks covered it nearly around the clock. The lawyers became household names. Witnesses became famous. The trial ran for months, far longer than anyone had predicted. And from the beginning, the two sides told two completely different stories. The prosecution's case was built on physical evidence, blood above all, DNA. In 1995, DNA evidence was still relatively new. In American courtrooms, powerful but unfamiliar. To most jurors, the prosecution presented blood evidence linking Simpson to the crime scene and the victim's blood to Simpson's car and his home. It sounded overwhelming. And then the defense stood up, and instead of denying the blood, it asked a different question. Not whose blood is it, but how was it collected? Who handled it? And can you trust the people who say where they found it? The defense strategy was clear, and it was effective. It rested on two ideas, argued over and over for months. The first idea was contamination. The defense argued that the Los Angeles Police Department's crime lab had been sloppy, that evidence had been collected carelessly, stored improperly, and handled in ways that could have corrupted the results. They memorably called the lab a cesspool of contamination. The second idea was far more explosive. The defense suggested that some of the evidence might not have been mishandled by accident, but planted or tampered with by police. It was a stunning accusation, and the defense knew it could not simply assert it. It needed to make a jury doubt the honesty of the police themselves. The technical demolition of the forensic evidence was led by Barry Scheck. Scheck was relentless, rapid, and precise. He cross-examined the prosecution's evidence technicians for days, forcing them to admit every mistake, every gap, every shortcut in how the evidence had been gathered. Scheck's cross-examinations were widely seen as a turning point. He did not have to prove the evidence was wrong. He only had to make 12 jurors uncertain enough that the word reasonable doubt started to feel real. Judge Ito, meanwhile, struggled to keep the trial moving. There were endless objections. There were long legal arguments held outside the jury's hearing. There were disputes over what evidence the jury could even be told about. And then came the single most famous moment of the entire trial, a moment that would be replayed for decades and taught in law schools. As a warning, the prosecution had a pair of leather gloves. One had reportedly been found at the crime scene. The other had reportedly been found at O.J. Simpson's estate. The prosecution's theory was that they were a matched pair worn by the killer. If the jury believed those gloves belonged to Simpson, it was devastating evidence. And then the co-prosecutor, Christopher Darden, made a decision in front of the jury. In front of the cameras, he asked O.J. Simpson to put the gloves on, to try them on, live in the courtroom. It was an enormous gamble. A demonstration like that cannot be controlled. No one knew for certain what would happen, and what happened was a disaster for the prosecution. Simpson stood before the jury and worked his hands into the gloves slowly, with visible effort, and the gloves appeared not to fit. Simpson held up his hands toward the jury box, tugging at the tight leather, and told the jury they were too small. The prosecution had explanations. The gloves were leather that had been soaked in blood and then dried, which can cause leather to shrink and stiffen. Simpson was wearing thin protective latex gloves underneath to avoid contaminating evidence. Those were real arguments, but they were complicated, and the image was simple. The jury had just watched a famous man struggle to pull on the gloves. The prosecution said he had worn to commit murder. No legal argument, no expert explanation could fully erase what 12 people had seen with their own eyes. But the damage was done. And months later, in his closing argument, Johnny Cochran would take that single moment and turn it into a phrase that an entire generation would memorize. The defense's deepest blow to the prosecution came not from the gloves and not from the DNA. It came from a police witness, one of the detectives who had been at the crime scene and at Simpson's estate was a key prosecution witness. The defense, in cross-examination, questioned him about whether he had ever used vicious, racist language and whether he might be biased. On the stand, the detective denied it under oath. And then the defense produced evidence, recordings made for a separate project in which that same detective was heard using exactly that kind of language repeatedly and viciously. It was catastrophic for the prosecution when the detective was recalled to the stand and asked direct questions, including whether he had planted or manufactured any evidence. He refused to answer, invoking his constitutional right against self-incrimination. Think about what the jury just heard. A central police witness had been caught lying under oath about his own bias, and then asked point blank whether he had tampered with evidence. He would not say no. The defense did not need to prove a conspiracy anymore. The detective's own collapse had handed them reasonable doubt. In late September 1995, the lawyers gave their closing arguments. Marcia Clark urged the jury to look past the spectacle, to focus on the history of violence and on the trail of evidence. And then Johnny Cochran rose to close for the defense. Cochran was a master of rhythm and memory. He told the jury that the case was about more than 2 murders, that it was about whether they could trust the police and the evidence at all. And he reached back to that moment with the gloves and gave the jury a single line built to be unforgettable. It was, as pure argument, enormously effective. 5 short words that compressed the defense's entire theory: doubt, mistrust, and that one televised moment into something no juror could forget. In the deliberation room, the case went to the jury. In early October 1995, the trial had lasted nearly 9 months. It had heard more than 100 witnesses. The jurors had been sequestered, kept away from their normal lives, their families, and the news for hundreds of days. One of the longest jury sequestrations in California history. Given the length of the trial, most observers expected the jury to deliberate for many days, perhaps weeks. Instead, the jury reached a verdict in only about 4 hours when the news broke that a verdict had been reached. The country essentially stopped. The verdict was not read out. Immediately, it was held until the next morning. And in those hours, an extraordinary thing happened across the United States. Tens of millions of people arranged to be in front of a television at the same moment. On the morning of October 3rd, 1995, in courtrooms, offices, schools, and homes, an estimated 150 million people watched and waited in the courtroom. The clerk took the verdict form and began to read. The clerk read that the jury found the defendant, Orenthal James Simpson, not guilty of the murder of Nicole Brown Simpson and not guilty of the murder of Ronald Goldman, not guilty on both counts. After one of the longest, most expensive, most watched trials in American history, the jury had acquitted O.J. Simpson in about 4 hours. And the reaction revealed something that the trial had exposed all along. News cameras captured Americans hearing the verdict, and the reactions often divided sharply, painfully, along lines of race. Many Black Americans who had watched a police witness exposed as a liar saw a justified acquittal and a rare check on a distrusted system. Many white Americans, looking at the physical evidence, saw a guilty man set free. The same trial, the same verdict. 2 nations watching 2 different stories. The criminal trial was over, but the legal story of O.J. Simpson was not. The families of the 2 victims then brought a civil lawsuit against O.J. Simpson for wrongful death. And a civil trial is very different from a criminal one. In a criminal trial, guilt must be proven beyond a reasonable doubt, the highest standard in the law. In a civil trial, the standard is lower, a preponderance of the evidence, essentially more likely than not. In 1997, a civil jury heard the wrongful death case. That trial was not televised, and it moved differently, and the civil jury reached the opposite kind of result. It found O.J. Simpson liable for the deaths of Nicole Brown Simpson and Ronald Goldman and ordered him to pay tens of millions of dollars in damages. So, the legal record of the case holds 2 verdicts that seem to contradict each other, but in law, do not. A criminal acquittal because the state did not prove guilt beyond a reasonable doubt and a civil finding of liability under a lower standard of proof. Together, they became one of the most powerful real-world lessons ever taught about how the burden of proof actually works. The trial also permanently changed American courts and media. The chaos of the televised proceedings made many judges far more cautious about allowing cameras into high-profile trials. It helped launch an entire industry of round-the-clock legal television. And it became a permanent reference point, the case lawyers and scholars still reach for when they discuss celebrity, race, policing, and the burden of proof. Years later, in an unrelated case, O.J. Simpson was convicted of serious felony charges in Nevada and served years in prison before being released on parole. He died in 2024. The murders of Nicole Brown Simpson and Ronald Goldman, in the eyes of the criminal law, remain officially unsolved. The O.J. Simpson trial is remembered as a media spectacle. The Bronco, the glove, the cameras, the line everyone could recite. But underneath the spectacle was a real courtroom doing a real and difficult thing. A jury was asked not whether O.J. Simpson probably did it, but whether the state had proven it beyond a reasonable doubt. Using evidence handled by people, the jury had been given powerful reasons to distrust. And on that exact question, the jury said, no, if you want to come with us to other courtrooms, to the trial of Lizzie Borden, to the dock at Nuremberg, to the day a court put a king of England on trial for his life. Subscribe to the highest court, because a verdict is an answer to one precise question, and a free society depends on everyone understanding exactly which question was asked